I have the honor to present the Centennial Medal Award, which was established in 1992 by the Law Alumni Association to recognize exceptional meritorious achievement. It is the highest honor the law school bestows on one of its graduates. The 2021 Centennial Medal Award goes to the Honorable Herbert E. Phipps, class of 1971. After law school, Herbert Phipps returned to Albany, Georgia to join the law practice of C.B. King. The firm emphasized civil rights litigation, including school desegregation, voting rights, jury discrimination, student rights, police brutality, and discriminatory employment practices. Judge Phipps served for 8 years as part-time magistrate and associate judge of the Dougherty County State Court. He served as judge of the juvenile court there for 7 years. Governor Zell Miller appointed him judge of the Dougherty Circuit Superior Court in 1995, and he served in that court until Governor Roy Barnes appointed him to the Court of Appeals of Georgia. He's been elected statewide to serve 3 6-year terms on the Court of Appeals. In 2010, he became a presiding judge of the court, and he served as the chief judge of the Court of Appeals from 2013 through 2015. Judge Phipps has received honors too numerous to list. A few are being honored as the legal legend by the Georgia Lawyer Chapter of the American Constitution Society and received the Nestor Award from the Georgia Legal History Foundation. He's been inducted into the Society of Benchers of Case Western Reserve School of Law, and he delivered our commencement address to the class of he delivered our commencement address in 2017 and then in 2014 at Atlanta's John Marshall Law School. He's a member of the joint 2021 Federal Nominations Advisory Committee of Georgia and a member of Sigma Pi Phi fraternity, Delta Delta Boule, the Inquiry Club, and the Old War Horse Lawyers Club. I might need to know more about that one. It is my great pleasure to introduce the 2021 Centennial Medal Award winner and tonight's keynote speaker, the Honorable Herbert E. Phipps.
Thank you very much, Dean Berg. It is indeed an honor to receive this award from the law school that I love so much. I was very much surprised when I was informed recently that I would be the recipient of this award, and I can tell you that anything that I have done to deserve it is because of the education that I got at this law school, because of the assistance and encouragement that I received from the administration, faculty, and staff, and fellow students. I'm so happy to see one of my favorite professors, Lou Katz, here tonight. He was a great professor during my time, and I learned so much from him, and I'm so happy that he's here. I want you to know that I could go on and on about my days at the law school, and there's much I could tell, but as I said, my administration, faculty, staff, and fellow students made a great contribution to my success at this school. And when I was informed that I would receive this award and that I would have an opportunity to speak to you, I began searching for a topic for my speech for this occasion, and I looked back over my life journey before and after entering the legal profession and decided on a topic which I think is appropriate for our time. And that topic is, where are the lawyers? Where are the lawyers? Historically, lawyers have been on the front lines of the fight for racial and social justice in this country. But I think far too few lawyers have entered the fray. A lawyer's voice can be heard and influence felt from anywhere in the profession. Yet, most lawyers are never heard from on these issues. Is it hostility? Is it fear? Is it indifference? Where are the lawyers? When I left this law school in 1971, 50 years ago, I went back home to South Georgia, excited about using my legal education in the ongoing struggle to dismantle the cruelly racist Jim Crow society in which I had grown up. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 were nice. But just as Brown versus Board of Education did not end segregation in the schools, these acts did not automatically end the Jim Crow practices that they were meant to stop. Enforcement was required. There was still much work to be done by lawyers and judges. I joined the practice of the late C.B. King, a 1952 graduate of this law school and one of the most courageous and best all-around lawyers I have ever seen. There is nothing that lawyers do that C.B. King could not do well. He was the only black lawyer in South Georgia, and he was waging a one-man battle against racial injustice in all of its forms. He needed help. South Georgia was well populated with white lawyers, but they would not pursue civil rights issues for their clients, even though such issues were present in most cases with black clients. Where were the lawyers? King and I accomplished a lot in the fight for racial justice in a wide range of areas, using Brown and its progeny and the acts of 1964 and 1965. But as you may have noticed, over the last few years, Jim Crow is buried in a shallow grave. Often, we had to fight the same battles over and over and over again. But of all of the available tools, nothing was more effective than the Voting Rights Act in changing attitudes and behavior and diminishing Jim Crow practices. For that reason, watching the Supreme Court butcher the Voting Rights Act as it did in 2013 and again this year has been extremely painful. When the Chief Justice wrote in 2013 that the act had served its purpose and certain protections were no longer needed, His poor judgment reminded me of the farmer who put a lock on his barn door to stop the stealing of his corn. After several years, he thought, the stealing has stopped and I can take the lock off. He did. The next day, the corn thieves returned. The Supreme Court took the lock off the door, and the next day, the racist attacks on voting rights started again. And now, they are in high gear. The Supreme Court has sent us back to the Edmund Pettus Bridge. We have to redig this old well. Forget about the shallow grave. I was wrong. Jim Crow is not dead. Our Supreme Court has resuscitated him. Without a strong Voting Rights Act and vigorous enforcement, we will lose many of the social justice gains that we have made since 1965. That is the intent of the governors and state legislatures who are currently so busy with racist gerrymandering and voter suppression legislation. That is why the U.S. Senate killed consideration of the Freedom to Vote Act on Wednesday. Their goal is to take us back to an era that we thought was bygone. I can see it coming like rain on the horizon. Several years ago, I saw a South Georgia judge refuse to do his duty to release or set bail for several persons who had been jailed for peacefully protesting racial segregation. In the privacy of his chambers, away from the crowded courtroom and the media, the judge told the lawyers that although he knew that it was his duty to release the prisoners from jail or at least set bail, he was not going to do either because he said, and I quote, "I have to live in this little town. I have to live in this little town." He returned to the courtroom, announced his decision, and several innocent people remained in jail for many weeks because that cowardly judge had to live in this little town. Now, that was long ago, but life goes on in much the same way. We still need lawyers and judges with the courage to do and say the right thing, even if it makes them unpopular in this little town. The nature of what lawyers and judges do is such that when they do the right thing by unpopular people in unpopular causes, they should not expect to be popular. Lawyers and judges must have the courage to do the right thing when the whole world is watching, and the character to do the right thing when no one is watching. In 1859, Frederick Douglass said, "Our national house is on fire." In our current social and political climate, I think that it is fair to say that our national house is on fire again, and good people, including lawyers, are standing around silently watching it burn. Difficult times require good people who are more than just passively good. Passively good people give new meaning to the term good for nothing. Lawyers have the special training to do more public good than any other members of our society. For that reason, the silence of good lawyers on the pressing social justice issues of our time is especially disappointing. Silence is complicity. A good lawyer should be aware of the injustices of society and have enough courage and concern to confront them openly and take a reasonable share of responsibility for correcting them. Speaking at the University of San Francisco Law School in 1962, Attorney General Robert F. Kennedy said, "Courage is the most important attribute of a lawyer. It is more important than competence. Courage is the most important attribute of a lawyer." And in my Georgia experience, when people ask about a lawyer they might hire or a judge who will preside over their case, at the heart of their inquiry is a concern about courage. They don't ask where the lawyer went to school or where the judge went to school or their class rank. The only thing they want to know is, will this lawyer fight for me? Will this judge be fair to me? They want lawyers and judges with the courage to say and do the right thing, despite any social, political, or community pressures in this little town. In that same speech in 1962, a time of unprecedented racial turmoil in the South, a time when ordinary people, black and white, were risking their lives, their livelihoods, and everything else in the fight for racial justice, Attorney General Kennedy went on to say, and I quote, "Lawyers have their duties as citizens, but they also have special duties as lawyers. Their obligations go far deeper than earning a living as specialists in some area of the law. They have a continuing responsibility to uphold fundamental principles of justice from which the law cannot depart." One of my great disappointments in our present efforts to deal with the situation in Mississippi as lawyers has been the absence of any expression of support from the many distinguished lawyers of that state. I realize in that difficult social situation that to defend the fundamental principles of respect for the law and compliance with federal court orders would be unpopular and require great courage. I also understand that many of them may not agree with the decision in Brown versus Board of Education, but whether they agree or not, they still have their obligations as lawyers, and they have remained silent. But whether they agree or not, they still have their obligations as lawyers, and they have remained silent. End quote. Where were the lawyers? Good lawyers remain silent in that difficult social situation. No courage. Silence is the best evidence of no courage in a lawyer. Now, courage is not risk-free. The courage to stand up and speak out against racial and social injustice may carry professional, social, or political risks. Nevertheless, as Ambrose Redmoon wrote, courage is not the absence of fear, but rather the judgment that something else is more important than what you fear. A lawyer's continuing responsibility to uphold fundamental principles of justice is more important than the risk of losing a friend, a vote, a dollar, or being unpopular in this little town. A lawyer who neglects this inherent continuing duty is an incomplete lawyer. 50 years from now, when people look back on the pressing social justice issues of our time, I hope that they do not have cause to ask, where were the lawyers? Our clients do, but we lawyers do not have the right to remain silent. Our clients do, but we lawyers do not have the right to remain silent. Thank you very much. Thank you. Thank you very much. Thank you. Thank you. Thank you very much. Thank you. Thank you. Thank you.